All right, administrative law judges all found to be unconstitutional. What is going on? There's some major freaking breaking news right now. The DOJ just issued a memorandum as the acting solicitor general that made it a finding that administrative law judges, that's going to be under the Administrative Procedures Act, Title V, APA, and their way that they're being disciplined, the way that they're being handled for mismanaging cases is unconstitutional as applied. That's the DOJ's opinion. Check this out. All right, so this was Chad Mehl. Now, he is the chief of staff at the DOJ under Pam Bondi and POTUS, and he just posted this. Officially, looks like it was February 20th, 5:10 p.m. So, pursuant to 28 USC 530D, I'm writing to advise you the Department of Justice has conducted multiple layers of removal restrictions on administrative law judges, ALJs under 5 USC 1202 and 7521 violate the Constitution. The removal provisions of the judges violate the Constitution. That the DOJ will no longer defend them in court, and that the department has taken that position in an ongoing litigation. I mentioned a couple cases. Executive orders are contrary to to Article 2 powers, which is the executive power over the president, where the president has control over how to run the executive department, not administrative law judges. President may not be restricted in his ability to remove a principal executive officer, who is in turn restricted to his ability to remove an inferior executive officer. A federal statute provides a federal agency may be removed only by an ALJ, only for good cause, as established in this case, Merit System Perfection Board on the record of an opportunity of a hearing board, 5 USC 7521A. Another statute provides that the member of the board may be removed by the president only for inefficiency, neglect, or duty of malfeasance in the office. That's 5 USC 1202. So, consistent with the Supreme Court's decision in Free Enterprise Fund, the Department has determined that those statutory provisions violate Article 2 and restrict the president's power to remove principal executive officers, who are in turn restricted by their ability to remove their inferior executive officers. So these statutes, these administrative law statutes, APA, they say that if you want to get rid of an APA judge, you got to follow this procedure to do it. You got to go to the APA board, and he goes and has a review hearing there. The president cannot remove an administrative law judge under these statutes unless he finds it was inefficiency, neglect, or neglect of duty, or malfeasance in the office. He can't just say you're fired if he doesn't like the judge, like the president could do in many other branches. So what the DOJ is making a opinion at this point, this seems like an opinion piece, and I don't see why they didn't put opinion, that they believe it's unconstitutional as applied. It looks like they got a court case going on. So, what are the effects of this, man? I'd say there's a lot of people who are into conspiracy theories. This is a major effect. I'd say if you're a conspiracy theory person, then this is could be a really big deal. Let's just kind of explore that. Like, let's say I was a conspiracy theory person, which I'm not in a way. I mean, dude, I like looking at the law, facts, the theory that I can't control. It's a rabbit hole that I don't like going down unless it's supported in facts and law, but let's explore what the theory would be. Potentially, probably people who believe in conspiracy believe that this might be a part of like Jasara and Asara. I don't see any basis for that. Now, just FYI. Now, that is like a court case that happened, I think it was in the 80s. A farmer back during Farm Aid brought a case under something called Asara, went to court, and then in the 90s, like early 90s, it went supposedly into all the way up to the Supreme Court. Then supposedly the theory is it got sealed by Clinton, and they brought in potentially another form of government at that time with Bill Clinton. And that's wild conspiracy theory with no basis in fact or law. But that's what a lot of, entertainment purposes people believe on the internet, and there's no support on it. So that's kind of that side. That'd be exciting. Wow, maybe that Nassar stuff's real. They're doing it this way now and they're showing it this. Okay, that's like their theory. But the way I'm seeing it is that it's actually just President Trump is trying to get rid of these administrative law judges, and he's finding that these people are protected by the statute. So he can't get rid of them. Even if the judge is doing if he's doing malfeasance in office, yeah, he could get rid of him, potentially. But if he's not doing malfeasance and he just says, I want to get rid of this judge, he can't. And so he's having the attorney general is now looking at this and saying, well, this is, let's make an opinion on this. Now, the other theory, this is going to be conspiracy theory side, is that a lot of these judges acting in state courts, maybe a small claims case, a landlord-tenant court, maybe, and I don't have any basis for this, but maybe they're also administrative law judges. I don't know. I don't know where people come up with that theory. I don't have any support for that. In my opinion, they're not administrative law judges. They're superior court judges, as long as they have a proper oath of office under the Constitution. They don't have a proper oath of office under the Constitution, which is Article 20, Section 1 through 23, Section 3. They don't have that, and they only take half the oath. Well, yeah, they're probably a BS judge, and they have no right to be there. Guess what? I pulled the oaths of office on some judges, a bunch of them. They don't even have the full oath. They only take the first part of the oath. So it's definitely possible that, why don't they take the rest of the oath? Oh, well, they said a case went before them in the 1960s, before the Supreme Court, that said that they don't have to take the full oath anymore. That was a Supreme Court case in the 1960s. But can the Supreme Court of California change the Constitution without a legislative amendment or a constitutional amendment? Think about it. Article 1, legislature. Article 2, executive. Article 3, judicial power. Can the Article 3 branch change the Article 1 power? It can interpret it, right? And it can interpret the statutes and interpret what the Constitution says and base it on facts. Yes. But can it actually change it and say, we don't want to use this part of the Constitution anymore, strike that, get rid of it? Can it do that? I would say a hard no. Absolutely not. Well, that's what the California Supreme Court did in the 1960s. They think they can do that. And that's why we've been running some insane judicial chaos, I think, in California ever since. A lot of it because of that, because they don't take the proper oath, and they feel like they're above the Constitution on that. They don't need to because of a Supreme Court case. So that supports the theory that maybe these guys are just administrative law judges in California. Maybe they are. I want to just explore that. Maybe they are. And if they are administrative law judges, then they could be removed. The DOJ saying by this. I don't know. That's federal law, APA. So it may not apply to the states. It probably doesn't apply. But either way, it's a federal law over the federal federal administrative law judges. All right. So that's the way I'm seeing it. Rather cool. Breaking news on on how this is going down in DOJ, making a finding that administrative law judges are unconstitutional on their removal process from office as applied. That's kind of a big deal. So little plug on that. It's breaking. I wanted to get it out there. If you like this video at the ones, share the freaking video, leave a comment. Tell me what you think. Are these judges just administrative law judges in these states? Or are they actual judges under the Constitution taking proper oaths? Let me know. My name is Gavin Mehl. I'll see you at the top.